Our next speaker is Paula Tobler. Paula is a supervising attorney at Disabilities Rights California. Paula works at DRC, and she's been there since 2008, I believe. And Paula, please correct me if I'm wrong. And she works in the Pathways to Work Practice group. She came to DRC from private practice as a labor and employment attorney because of her interest in employment opportunities and reasonable accommodation for mental health disabilities. Since becoming a California bar 30 years ago, she has practiced law in many different subject areas. She attributes her current career path to being in a significant auto accident 22 years ago that gave her personal experience with traumatic brain injury and post-traumatic stress disorder. Paula said, carrying these diagnoses and seeing the disparity between what I can do with little to no accommodation and what others assume I can do based on misconception of my diagnosis lit a fire in me to educate and advocate for others in similar circumstances. So please join me in welcoming Paula Tobler with DRC. Paula, floor is yours.
Hi, everybody. I understand we are running a little late, so I'm going to keep my remarks pretty short. And fortunately, a lot of people before me have kind of filled in a lot of what I was going to say anyway. And then maybe reserve more time for questions that might be helpful. So I do work at Disability Rights California. I haven't been here for that long, but I've been working in labor and employment for a while, done a lot of different things. As Bobby was saying, I had my own experience I was a practicing attorney doing litigation and trial work and doing very well in my career. And then I was in a major auto accident and ended up with traumatic brain injury and post-traumatic stress disorder. And I was also pregnant at that time with my second daughter, who now is in college, but it was touch and go for a while. And I have experienced the whole gamut from trying to work and not being able to work at all because of the extent of my disabilities to being able eventually to be back to being an attorney. And that has really helped me to understand from a personal basis and also to be interested in understanding from a legal basis how supports and accommodations and skill building and things like that can make a huge difference in the ability of people with disabilities to work and to perform the same jobs that people without disabilities do. And in fact, in a lot of ways, I think people with disabilities, in my own humble and probably biased at this point position, are better at. For example, one thing I've noticed in the COVID situation is a lot of people with disabilities, and Disabilities Rights California actively recruits people with disabilities. So we have a lot of people working here. People with disabilities tend to be very flexible when it comes to having to change everything around with very little notice. Because we've, in our personal lives as well as our professional lives, have had a lot of experience in just being able to find ways to get what needs to be done. We find our own ways of doing it. Sometimes we need some help from the outside, but we're used to being flexible, and we're used to creative problem solving, and we're used to just doing what needs to be done to be able to get what needs to be done in our lives. As far as the reasonable accommodations, the heart of that, as has been coming up repeatedly, is the good faith interactive process. Now, the bad news is that's very fact specific, which is probably why a lot of you have been looking for resources as to like what timelines should you be expecting or exactly how does this work. You're not going to find a whole lot of specific information because it's so fact specific. It's specific to what the accommodations are. what the employer situation is, what the job description is, because basically reasonable accommodations are only required, well, accommodations are required if they're reasonable. Reasonability has to do, or reasonableness has to do with the expense, other barriers that might be too much for the employer to handle. On the other hand, working for the state, you're in a good position there. They, do have a lot of employees. They do have resources that, maybe a mom and pop operation would not be able to accommodate some of the things that you would be asking for. But they also only have to accommodate certain difficulties with certain job duties. So you have to be able to perform your essential job functions with or without reasonable accommodation, or they do not have to keep you on the job. So when somebody was saying that they're understanding, this was somebody who was asking a question, seemed to be thinking that the understanding was that you have this good faith negotiation, you go back and forth until you come up with an accommodation that works. That's not always necessarily the case. Both sides have to be working in good faith, so the employer should be looking at, are there accommodations that would enable this employee to perform the essential job duties? Or the other question is, are these essential job duties? If they're not essential job duties, then they can just say, you don't have to do them. You can perform your essential job duties with or without accommodation, so we can work around the non-essential duties. But it's also important to remember that the employee has to operate in good faith as well. So what I see a lot is your very easy bad faith situation is the employee asks for accommodation and the employer says no. That's not good faith and it's not interactive, so they have to say why. Or they can say, we want medical documentation regarding these accommodations. Now, when it comes to medical accommodation, you do not have to provide your entire medical file. We see that a lot. We want a release sign so we can get all your medical records. They are not entitled to that on the basis of a request for accommodation. You can have your own medical provider provide a note. They don't even have to, in California, disclose your specific disability. They just have to say that you have a disability and that you require these accommodations because of your disability. Now, be aware that a lot of these medical providers, they're not lawyers who deal in reasonable accommodations. So if you just go to your doctor and say, I need a note about reasonable accommodations, it may very much hurt you what you get from your doctor. So it does help to go to the JAN network, which I noticed in the resources section of the, I'm having trouble with word finding right now, but the Job Accommodation Network, or JAN, is at askjan.org, and that's in your resources with the email that came with the agenda. You can go there and look up a different disabilities and different situations and get an idea of accommodations that have been asked for regularly or that have been accommodated, and you can see, oh yeah, that gives me an idea of something that will work. So if you go to your employer and say, I'm having a hard time with my job, it's because of my disability, but I'm not sure what I need to make it work, or I need a flexible schedule, but I can't really explain to you why that's related to my disability or why that's going to solve the problem, then it's going to be on you to clarify that. Now, if your employer comes back with a no or a maybe, they also have to explain their position. It might be maybe we have to look into how much, what exact assistive technology or other resources you may need and what that will cost and whether that is reasonable given our resources. Or they may have to do an analysis of essential and non-essential functions. Again, the state should be pretty on top of their job descriptions and things, but you never know. So then you go back and forth, and you keep trying to find a place. It's a negotiation. You keep trying to find a place where you can meet and agree either that there are accommodations that are reasonable that could be put in place for you to be able to perform your job duties, in which case those should be done within a reasonable time. And again, that depends on the facts and the employer and employee situation. Or you get to the point where you're at an impasse where you're saying, the employer is saying, we cannot reasonably accommodate you within your essential job functions. And so we can't do it. And at that point, you decide whether you are going to have to go find another job, or you can ask them for a reassignment. That is a possibility as well. Or whether you want to file with a state agency or with the DFEH or the EOC. And I would agree with the Brendan Butler, the DFEH person, that it is much better to file with the DFEH and go with them because, for one thing, they have a much faster turnaround time. The EEOC is backlogged a couple of years right now. The DFEH has free mediation available. So a lot of times you can get a mediation without waiting for a whole long process to do. You can get an immediate right to sue letter if you have an attorney that wants to do that and just wants to go to lawsuit. But also California law is much better on reasonable accommodations. And there's case law where they specifically state that California intended their laws to be better than the state ADA or the federal ADA laws on reasonable accommodations. And things like having a separate cause of action for failure to participate in the good faith interactive process is something that is available under California law, but is not a separate cause of action under federal law. So that's basically how that works. And I can tell you that, like for example, in my situation, shortly after the accident that I was in, they could not accommodate the essential functions of my job. They were not willing to give me permanent modifications or even long-term temporary modifications to see how long it would take to heal. And traumatic brain injury can take a while to see even where you're going to settle out. So they ended up cutting up that process and I had to move on from there. And then as I got treatment and recovery and time passed and I put a lot into the process of recovery, I was able to do other jobs. And then you go through that process again. And that was reasonable accommodation for that job, not for any job that I'd done in the past, but what this particular job with this particular employer, do I need accommodations in the first place? And often the answer to that has been no. Or no in general, but at times when my PTSD is flaring up or something is going on, I may need temporary accommodations. Other times, depending on the employer, it's a whole different discussion. The timelines also vary by employer because if you have, for example, the state that has people designated to do the reasonable accommodation process, you have a union that is involved in assisting you, there's a lot less excuse for it to drag on. On the other hand, if you're working in a smaller operation and they, only have one person that does any HR and they do it part-time because they have other job descriptions as well, they still have to do it in a fashion that's in good faith. They can't leave you hanging forever, but you may not get a same day response. The day you ask for accommodation, get a response like the state is saying that they are able to do. So that's it in a nutshell. Does anybody have any questions they'd like to ask?
Paula, actually, I have someone that texted in saying, you mentioned twice that employees have 1 year from the date of discriminatory event to file a complaint with their department. Their understanding is that employees have 3 years to file pursuant to a law effective January 1st, 2020. Do you know anything about that?
Yeah, that was not me saying they have 1 year. That was the state personnel person that spoke before me. And that has to do with two different processes. My understanding is she was saying it was 1 year for your internal process. As far as the process with the DFEH, it depends on when your claim arose, because starting in January of this year, if you have, it used to be that you had 1 year from the date of the discrimination, harassment, whatever adverse employment action under the FEHA, the Fair Employment and Housing Act, to file with the DFEH. Now, once you file with DFEH, the statute of limitations is told while they make a decision, and then you file with them. Starting in this January 2020, they changed that to a 3-year statute. But if your claims would have reached a year, like in December of 2019, that doesn't mean you get 3 years. It was not retroactive. But any claims that are ongoing now, like in 2020, let's say you're discriminated against because of your disability today, or you enter into an interactive process and you feel like they ended it in bad faith, and so we can't accommodate you, you can't be in this job, then that would be under the new 3-year rules.
Would anybody like to unmute and ask a question of Paula? We don't have any other questions in the chat right now.
If nobody has any questions now, you can possibly forward any questions that comes to your mind later on to SSTAC, and we can, if it's okay with Paula, we can forward that to you for a response. Would that be okay, Paula?
Absolutely. Also, Disability Rights California has a lot of materials in our self-help section that explain reasonable accommodations in both housing and employment that are very helpful. And you can reach me at, it's paula.tobler@disabilityrightsca.org. So you can reach me there, or you can call the main line for Disability Rights California on our website anytime and just ask for me, and you can be connected to me. I'm in our Los Angeles office, but we actually work statewide now. So I supervise people that are across the state. And the way it's working out now, I also are mentoring people in other practice groups. I'm in the Pathways to Work practice group, so this is primarily what I do. But I'm mentoring other attorneys in other practice groups that want to do more reasonable accommodation work. So we're ramping that up. So let me just check. I had a private chat, so.
Bobby, do we want to take one last question and then wrap it up? Because I have one in the text.
We're going to go ahead and take that last question. And the question is, what if you're discriminated, then terminated before you had a chance to get your RA?
Okay, if you are discriminated against and, if you have not disclosed that you have a disability and they don't know, they just terminated you for a performance issue, but you would have asked for an accommodation to address it, then you're going to have a problem because they're not expected to know. So as soon as you have a problem that you relate to your disability, or they bring up performance issues, or even if they're terminating you in the termination meeting, say, I have a disability and this is related to my disability and I want a reasonable accommodation. Make sure you get that in before you walk out the door, because it's going to help you tremendously in any wrongful termination lawsuit that happens after that. If they know or should have known that you have a disability, then they should be entering into the interactive process before termination. At the same time, if they don't, then bring it up and say, I want an accommodation. If you're in the interactive process and you are terminated before the interactive process has been completed, so they're not acting in good faith, they're not getting back to you, they just say, no, we can't accommodate you, we're firing you instead, then you're looking at a lawsuit. And you do have grounds to seek reinstatement. I will tell you up front that I've rarely seen that happen. I did have one case where I got reinstatement for someone, which was really good because it was the only high-paying job in his area. So he was really thrilled to get his job back. But very often what they want to do is pay you out rather than take you back. But you can ask in a lawsuit or for reinstatement to your job with back pay and to keep your benefits, et cetera. You're not entitled to that as a matter of course. They can pay you damages instead. You may end up in a lawsuit that takes a while to resolve, or it may be that they end up settling it. But then you would be looking for an attorney to represent you if you believe you were terminated for discrimination, disability discrimination, without going through all the processes that they are required to do before taking any adverse employee action. And obviously termination is an adverse employment action. My email address is put in the chat box, but it's actually a little off. So let me just put this in. Let me make sure I do this. Every time I try to type disability rights CA, I have to make sure I did it right. It's just .org instead of .gov. So you can do that. And then let me give you my phone number as well. So feel free to reach out. Feel free to check out our website. You can also look at the DFEH and EEOC websites. They have questions on this. They also have sections on COVID, as do we, because COVID is just another factor in reasonable accommodations. So it complicates things, but it's the same process. You know, you have to act in good faith and have an interactive process, and it has to be related to a disability.
Great. Thank you, Paula.
Thank you so much.
Excellent information, always informative. You've done this before with one of the DACs, my DAC. So thank you again for your generous contribution of time and the wealth of information.
Anytime. It is my pleasure to educate and to advocate. So I feel like this is doing both. Pass on the word, and let's make sure people get the accommodations that the law requires, so that they can do their jobs and show that people with disabilities are people, hardworking, good working people.
Absolutely. Thank you.